Siyam na siyaya, Ain't pek Kwulasultun tani snanemo, Ain't pek Clishan tani hupachasit, Ait na shkwalawan kwanas I haitsepka siyam mastimo. Good afternoon, everyone. My name is Doug White from the Snuneymuxw First Nation here in the Nanaimo. I really want to thank my cousin Lawrence for his opening words and opening prayer for us today. Thanks Stephanie and the others from the organizing committee, this particular speaker series, for the invitation to jump onto the important work and discussion presentation that Peter and Graham and Neil have put together for today. Stephanie and I, we've known each other all through our lives, and so we ran into each other, and she said, we're doing a talk about the Douglas Treaties. It's going to be, it's here in Nanaimo. It would be good if you could share a few words. And so I'm very happy to do that. I'm honored to be asked to speak with such esteemed scholars. This is one of the most important stories in our province, in our country, the story of these particular treaties and the progression and the arc that they've been on over the last 100 and whatever it is, 60, 70 years. It's truly amazing. The issues that the Crown and Indigenous peoples were grappling with back then are the same issues we continue to grapple with today in BC. Even the economy, the very structure of the economy that BC continues to wish for, it hasn't changed. Can you imagine that? There was a very good description from Peter at the beginning about the location of the treaties and why in these locations, and coal mining was the driving factor. The colony was desperate for an economic foundation for itself. It needed somewhere to settle, and therefore the Victoria area treaties. And it needed some kind of an economy to sustain itself, and therefore the Kwakwaka'wakw part of the world treaties, and then ultimately the Snuneymuxw Treaty, the final one. But I was on a BC AFN economic development panel maybe 3 or 4 years ago, and one of the heads of the BC Mining Association, whose name escapes me right now, he was giving a talk and talking about how, in this moment of the Chilcotin Nation decision and about Aboriginal title and this and that, we've never been here before, and it's going to be hard work to figure out how we sort out these issues in mining in this province because we've never been there before. And I was the chair of that session, and so I had to correct him. And I said, in fact, we have been there before. Back in the 1850s, the approach of the Crown was that, look, if there's a resource, a natural resource we want to extract in this province for economic purposes, and we don't have an existing relationship with the Indigenous peoples, then we need to do that first. We need to recognize that there's something called title and turn our minds to it and put some effort into it to figure out how do we get to a place of commonality with the Indigenous peoples. And that was the story in Snuneymuxw. We agreed that we would sell coal to James Douglas and his crew. I've always found it to be an utterly ludicrous proposition that my ancestors sold our territory to some characters that showed up on a boat for a stack of blankets. That's the most ridiculous proposition I've ever heard. But we had a discussion. It's important for everyone to know that the actual substance of the treaty, the terms of the treaty, it's not in the text of the treaty alone. It's not in the oral history alone. It's in, as a matter of law, the clear approach is to try to determine what is the shared and common understanding between the parties about what they did. And can we do that? So a remarkable history. I really appreciate the great scholarship of Peter and Graham and Neil that they've done. When I was the chief of Snuneymuxw going back to 2009, and I had grown up in a family. My father was a counselor, Doug White II. His father, Doug White I, was chief of Snuneymuxw during the White and Bob litigation. It was his cousin Clifford White was the accused there that had been convicted and et cetera, in the story that led to White and Bob. And David Bob from Slanawas was the other person. They were out hunting in the summer of '63. up in the southern slopes of Mount Benson had been charged for hunting deer out of season. And so we know about these stories in our community. We've always known about the treaty relationship. It's in a very, as a matter of the history of the practice of law and access to justice matters for Indigenous peoples and all of this. We all know the story of the Indian Act prohibiting First Nations from hiring lawyers from 1927 to 51. But by the 60s, there was a great failure of the legal system for Clifford and David when they were standing up from the prisoner's box in downtown Nanaimo at the Nanaimo courthouse in front of Magistrate Beaver Potts. And the lawyers, I think there was 2 or 3 different lawyers that abandoned them that summer. They were assigned and somehow they were supposed to be the lawyers. Lawyers, well, you know what, Judge, I'm asking permission to withdraw from this. I can't get any meaningful instructions from these people. And then there was this issue of, is the Indian agent going to come and speak from Cowichan? Or is he going to come and talk and say, does he have something to say about this? Because what happened so they were hunting July 7th 7th. July 8th, they were in front of the magistrate and their answer, he said, well, what do you guys say to this charge? Clifford stood up and said, my answer to this charge is, he called it a treaty of peace. There's a treaty of peace between our people that allows us to hunt in the way we were hunting. And so that was him standing up based on his knowledge from his community, his family, his people, about what permits him, what's the legal framework within which he goes hunting to feed his family and to feed his community. By September, Magistrate Beaver Potts had gotten tired of all of the delays, and he asked them then, so do you guys have something to say or not? Do you have evidence? Like, do you have anything to say for yourself? And they said, in fact, we do. And we want Joe Elliott from Cowichan, one of the major Coast Salish historians. He was like a historian of the Coast Salish people. We want him to come and talk. And so he was the judge, after arguing about this, allowed him to come forward. And so Joe Elliott stood up and he had with him a photostat copy of the book that Neil showed us from 1875. And he started to read from it, right? I mean, that book it's papers connected with the Indian land question. And the whole opening segment of that book is a restatement of the texts of the Douglas treaties held down in the BC archives. So he started to read. He was reading from this is what it says about the Stanemo. This is what it talks about their hunting rights. And the judge just shut him right down, turned it off and said, you know what, I'm going to stop you right there. Everyone in this province knows that there was never treaties made here. So I don't know what nonsense you're talking about. And that's it. I'm convicting you, Clifford, and David, you're convicted. And he fined them, and they weren't able to pay the fines, and Clifford White ended up in jail. But so when Tom Berger got involved, Maisie Hurley brought Tom Berger in. He was just, you see the pictures of Tom, he looks like a teenager. He's so young. And that great man, one of the great Canadian jurists in Canadian history, he just passed away last year, Tom Berger. But he was brought in for the first time to deal with and grapple with Indigenous issues. This was his introduction to Indigenous conflict with the Crown. I remember having coffee with him years ago. I sat down he had an office at the Marine Building in Vancouver, and we were having coffee downstairs. And I said, because what's remarkable when you read the Court of Appeal decision, by the time they got up there and the other decisions, I said, it's remarkable what you guys did in that case. How is it that you effectively argued everything that we've continued to argue all through the last half century? You know, because their first line of argument was that the document is a treaty. Because why? Because, you know, it's 1963, the Crown, for more than 100 years at that point, had denied the need for treaties. And part of that storyline, a political storyline of denial of the need for treaties or the recognition of Aboriginal title, was we better at the same time suppress the reality of the history of 1850 to 54 treaty making on Vancouver Island, because that's inconsistent with our political story that we're trying to continue to carry on with through the all through the early part of the 20th century through the 1963. Very powerful denial. And this is where the work of these scholars is so important. So okay, let me quickly say, so when I asked him, how did you come up with this? Because he argued first and foremost that there is a treaty. If that's rejected, then the second line of argument was, we're going to talk about the Aboriginal rights and Aboriginal title of the Snuneymuxw to do what they were doing. So you choose which one you want to grapple with. Ultimately, they won on the treaty arguments, of course. But I said, where did that come from? How did you arrive from Vancouver, you know, criminal defense lawyer in Vancouver doing random, like, where did all of this come from? How did you put all this forward? And he said, well, I came to Snuneymuxw, I sat down with the elders and they told me the story of these treaties. I'd never heard about a word about these before. Magistrate Beaver Potts, who'd practiced as a lawyer and sat on the bench, he'd never heard a word about these treaties before. And so he went down to Victoria and went and dug around. He went and he got a hold of people like Willard Ireland, the provincial archivist, and Wilson Duff, the provincial anthropologist. And he went, you know, he found the documents that Neil was talking about, this, you know, this ledger of land conveyances that Douglas had stuffed away in whatever government office and ultimately ended up in the BC archives. He said, we need to get this in as evidence. And so, notwithstanding that the elders have this story and an oral history about what this treaty is and what it means, we need to get the text of the document in, because I don't think any Canadian judge is going to be listening to elders yammer about the oral history of this or that in the 1960s. So, but if there's a written document, then maybe somebody will listen to it. And so the way to get the document is have the provincial archivist bring it in and submit it as evidence, put in as evidence. It was like exhibit number 8 or something of the defense. And there it is, it's in. Now, remarkable to me that when I, you know, so they win, right? They go up to the Supreme Court of Canada by 1965, confirms the BC Court of Appeal decision, and it overturns and upends the whole Crown narrative of the fact that there was never treaties, and whatever these things were, they were not treaties. They were some kind of land purchase thing. Unbelievable that we had to do that, like a basic fact of history argument. And so, you know, I hear about all this history from my grandfather, from my father, my family, my community, cousins, all that kind of stuff. And I go to law school to, you know, learn about the rule of law and all these beautiful concepts and ideas, right? And the Quebec secession reference. You read what the Supreme Court of Canada says about what are the most cherished and fundamental legal values and principles that hold what we call Canada together. One of the pillars of that is the rule of law. And so you learn about all these beautiful things, right? And then somehow I end up becoming the chief of Snuneymuxw in 2009. I sit down in that seat, and I have never seen so clearly how powerfully the Crown was continuing to deny all of that history. They were denying still that a treaty had been made in 1854 with my people. They were effectively denying that the Snuneymuxw had gone to the Supreme Court of Canada in 1965 and had won recognition of those rights in that treaty. They were effectively denying that the Constitution in 1982 in Section 35 says what it said. Like, the capacity for denial, stunning and shocking. And so when I was advocating as a chief of Snuneymuxw to try to figure out how do we work to implement, like what you know, we're like a large nation, we're well situated in an urban context, but oh my God, we're dirt poor, basically flat broke, none of our own money, nothing. The smallest tiniest little Indian reserves that exist in this country. 267 hectares of land, most of which goes underwater every winter when the tide comes up and there's a big rain, a flood. You go compare that to Osoyoos, who has 32,000 acres of reserve land, right? And 400 or 500 members. The Snuneymuxw has suffered structural poverty, dispossession. And so when we sat down as a government, we said, look, we need to better have a quick talk here. And when I showed up with my counsel, And I need advice, direction. We need to have a discussion how to get out of this mess, because I am not here as the chief to administer poverty for my people. I'm not here to hand out band-aids. I need to know right now, how are we going to change and transform this basic reality? And when we looked at everything, you know, all we have is a pop stand and a chip stand. That's what our economic development was. You know, and then we would lease a little bit of land to the mill on the south end of the, I mean, holy man, what a mess. What a disgraceful situation. When we looked at the overall context, we knew that, and we looked at all the opportunities that lay in front of us. What possible tools do we have to wield to make a difference and to change that? We settled upon the Douglas Treaty rights as the most powerful legal rights, that, as far as I'm concerned, that exist in this country, and at the same time, that are utterly and completely disrespected and unimplemented by either crown. Unbelievable, but nonetheless, very powerful tools. So we began to deploy them. As part of the deployment and implementation strategy, we realized that, you know what, there is a massive gap in general public knowledge about these treaties and what they mean. But part of the history of denial of the crown plays over and spills over into the academy and into the universities. What academic is going to research treaties that never happened, that didn't exist, that are not recognized by the crown? None. None did. Even by the time I was chief, deep into the 21st century, I said to staff, gather up everything that's ever been written about this stuff. I want to see what it looks like. I want to know everything that everyone's ever written about the land rights under the treaties from Vancouver Island, the 1850s. I want to know what anyone's ever written about the fisheries rights, the hunting rights. I'm telling you, it was a very thin set of documents that Peter talked about. Lots of sort of this stuff that is obscure and hidden in litigation and etc. And so we said we need to do that work. And so we held a conference in 2012 with Vancouver Island University on the treaties as part of that initiative. And John Lutz, who worked with these fellows, he reached out to me. What we had, and one of the other things we did is we set up the now defunded Center for Pre-Confederation Treaties and Reconciliation at VIU to bring attention to you know, what the TRC said so powerfully about the education system in this country. They said much of what is wrong in this country, the responsibility for that rests at the feet of the education system of Canada, both for what it taught Canadians and for what it didn't teach Canadians, for the omissions, what was left out in people's general education that you would get as a Canadian. And so the absolutely essential and important work of focusing attention and bringing attention to these things through the 2012 conference. And then John Lutz reached out 2014 to talk to me about, you know, about doing a second conference. Unfortunately, my son, my beautiful boy, Willem, ended up with cancer that year. And so I had to tell John, look, we can't co-host at the center in Nanaimo. I'm not here anymore. I'm just dealing and focused on my boy and his health. And so John, you know, he pivoted to the wonderful Songhees people and all of the people that have been described. And this is such important work, the gathering up of people to talk. I know that I was there, I went to the conference. I was called as a witness and I watched, and it was like two worlds slowly trying to figure each other out. The academics over here doing their academic, some of them were really kind of in their academic conferencing mode, and then half the room was Indigenous peoples from the treaty areas, and they were going, what are those people talking about? We don't know, what are they speaking English? You know, we talk about Chinook and trying to translate between two worlds is like, what is going on? And it created, you know, tension or whatever. People stood up and talked. And that's fine, right? I mean, that's how it's gonna be until we continue to talk and work through. And so this important book it's such an important book because it gathers up and it states important understandings and the product of the most highly educated people in our society, turning their sharp minds and lenses towards this issue to help all of us understand what happened in the 1850s and 1854, so that we can better today understand how are we meant to behave today, so that we're not carrying on with the nonsense of the last 150 years, but that we're living up to what is the best version of who we can be together. There's no way that any people should ever be subject to having to litigate for basic rights in the way that Indigenous peoples have for so long now. So it's up to Canadians and British Columbians, people who live on Vancouver Island, to inform themselves about this and to help shape that different future. And with the work that these people have done, the Songhees people with them, the Kwakwaka'wakw speaking peoples with them, they're helping us, right? They're lifting us up. They're opening our eyes and they're shining light, and they're creating the understanding that is the essential material that can lead towards meaningful reconciliation. Because we can't be reconciled if we don't understand each other, if we're not talking the same language, if we're not working together to have meaningful dialogues to help us understand who each other is and who collectively we should be together in a respectful relationship premised on recognition, respect, mutuality. So with that, I want to really thank you for the opportunity to share a few thoughts about this important work. Peter, Neil, Graham, Stephanie, Lawrence, and everyone that's here, and everyone that listens to this talk. This is such an important and essential knowledge to be shared. And so I'm grateful that people have put time and effort into this, because we're backfilling a major omission from the last 150 years of our history together. We're creating a new solid foundation upon which we can stand. So Haitsepka Siamistimo, Haitsepka, really thank you very much